It's all yours.
Morning, folks, and thanks for the invitation to present on this critical topic. I've been doing this work for a while, and honestly, I'm very interested. It's my first engagement with ANV, although I've been lucky enough to sit on the board of senior services for Alexandria out here where I practice. And it sounds like we're a fairly similar nonprofit. We have a lot of the same programming, but I've been taking notes here because we lack your robust happy hour schedule. So hopefully, we'll be adopting that as well. That sounds like a really good time, and hopefully, I meet you at one of those. So I don't think we have all that much time today. The topic is estate planning 101. And so I'll just dive right in. As Gary said, you could just ask questions away and they're going to populate here on the right-hand column of my screen. And this is a conversation. So I'd be happy to address them as they roll in. Perhaps some make more sense for me to defer till the back end, as I intend to address that topic in the presentation itself. But feel free to just fire away with any questions. What I can tell you is people ask what I do. I tell them, well, I'm a trust and estates attorney. What does that mean, right? We go by a lot of different things. There's an estate lawyer, a probate lawyer, an estate planner. Really, what we self-identify as within the bar is trust and estates. And that's because there's really kind of two worlds we operate in. Estate planning, that's the part most of us enjoy the most. And most of my practice is devoted to that, thankfully. And that's what we're going to get into mostly today. But kind of hand in hand with that is the other side of what a trust and estates lawyer does, and that's administration. Administration depends on the level of estate planning, if any, that a decedent had, because once they've passed, either their probate estate will be administered in a very procedure-driven process called probate, or their trust will be administered. And it's completely different night and day, depending on which road you go. But we're going to focus more on that first part of estate planning. Estate planning itself, in my mind, essentially has two hemispheres of its own. There is what we call core estate planning. That's your basic me estate plan, what everyone should have, or the things people like to have when they do their estate planning. And then there's kind of that other level. We call it tax planning. You may have heard of irrevocable trust planning. There is an entirely different menu options. There are probably about a million reasons people engage in irrevocable or tax planning, with as many different irrevocable trusts to address that specific situation. Again, we're going to focus on the core for purposes of this. This is the 101 class, not the upper level. A trust and estate attorney, I think, ought to have a facility to handle both planning and administration, and then both core planning and irrevocable trust or tax planning as well. So focusing on the core plan, I like to present it kind of this way, particularly with a new client who's not got anything in place. There are basically three species of a core estate plan. The first one is what we're all born with. It's the no plan plan. And that's not to be cheeky. In fact, it can work quite effectively for a lot of people. And what we call the no plan plan is a scenario where you may not have done any actual estate planning. You have no documents that govern anything. But you have been very religious in the way you title your assets. And so beneficiary designations can control pretty much everything. And it depends on the asset. Not every asset can be so designated, but the way assets themselves are titled legally, the name of the asset and anything that falls under its title is what controls at death. And so a no plan plan is potentially all you ever need if, well, to be crude, if the right people die in the right order and you never lose your capacity. Because, of course, this plan speaks nothing at all to, well, what about your physical body and your assets if you're still alive, but not able to really handle your affairs anymore? We'll get into that in quite some depth because what tends to happen there, if you lack the documents that control those situations, is someone's going to court to get appointed as your guardian or conservator. So there is a guardianship of an incapacitated adult, and there is a conservatorship. The guardianship is about the physical well-being of that principal, their body, procedures, where they're going to live, what type of care they're going to have, what doctors they're going to see, what procedures they're going to undergo. And the other one, the conservatorship, well, those are your assets. That's basically just how do I access and maintain this person's assets for their well-being since they can no longer do it themselves. No plan. A lot of people just do not wish to kind of engage with estate planning because it's to some a really morbid subject. I honestly don't find it to be that at all. And I often introduce myself to folks as a recovering litigator. It's true. So when I was a young man, all I wanted to do was be a JAG. I wanted to be a JAG, and I wanted to try cases, and I wanted to serve my country, and I wanted some adventure. So that's exactly what I did. After law school, I clerked for a judge for a year in my home state of Maryland. And then I went to the officer school and the JAG school, and I became a first lieutenant in the United States Army JAG Corps. And I said, okay, great. Where's the courtroom? And they sent me to my first duty station, which was Germany, where I was for about 3.5 years. And they said, no, buddy, we don't put folks like you who didn't go to West Point or weren't ROTC cadets. You're not getting in front of a military jury, tell you know how to wear that uniform correctly and salute, right? I mean, it's been a good year of training and all that, but still you're not ready to really carry yourself as a military officer. So we're going to stash you in something we call client services. I was a little disappointed by that. So I'm in Germany and I go to client services or legal assistance, whatever you call it. And it's essentially all the basic personal legal affairs that need to be addressed by a soldier, their family members, and then in Germany, DOD and Department of Army civilians and their families. What was unique about Germany was these 55,000 Americans in the community I was living in, 55,000. I think it was the biggest one outside of the United States at the time. It was Kaiserslautern, Germany, co-located with Ramstein Air Base and Landstuhl Hospital and all that. And they have no access whatsoever to an American lawyer. So they have a very robust, expanded legal assistance center. And it was very high volume, very interesting. Typically, when we were trained about legal assistance before we put on our uniform at our first duty station was, this is getting that 19-year-old soldier out of the 19% interest rate on the truck he just bought, or handling the disastrous landlord-tenant issue, things like that. But here it was really high volume and really focused on estate planning. I probably wrote 150 wills that year. Powers of attorney, advanced medical directives. The IRS came out and did training to certify me as the officer in charge of our tax center and about 20 educated soldiers on how to process 1040s for all these 55,000 people who didn't have access to someone back home. So that was my first foray into estate planning. And while I thought it was something I wanted to just knock out and get out of the way so I could go do what I came here to do, I ended up absolutely loving it. Estate planning is what I tell people kind of the best kept secret in the law. It's the only practice area I've ever touched or seen or experienced where you have happy clients, where you're doing a great service for your client as you're doing in a lot of other practice areas. But here, there's peace of mind where most other practice areas deal with stress and pressure and litigation. And so even when I was a litigator and had a very successful matter, that client didn't really want to see me again necessarily, right? I mean, I'm associated with probably the most stressful 2 years of their life on average. So I really came to love estate planning because it's call it a full contact sport where you really get to know your client because that's where you can actually add value. Not to besmirch any form services or online platforms. We don't compete with them at all. But our approach and in most actual law firm approaches is to will give legal advice, right? And then what is generated for you is customized to your situation to meet your goals. So that is how I came to really understand what estate planning was and helping folks transition from the no plan to the next step, which is a last will and testament based plan. Everyone knows what a will is, right? It's been around since Roman times. It works. And it's essentially a written document with some very specific formalities about what needs to be in it, how it needs to be witnessed and executed. But it's essentially, as you know, your opportunity to say what you want to have happen with your property, how debts should be handled, how taxes should be resolved, and who is going to handle that, who's going to execute the will, who's going to be the executor. And in a will-based plan, that's kind of the center, because that's the testamentary document, the document that speaks at death. If you pass away with a will, you have what a lot of people describe as a first-class ticket through the probate process. But you are going through the probate process. That is where a will is supervised as the estate is administered under the supervision of the county, both the circuit court and then their accounting arm here in Virginia called the Commissioner of Accounts. A lot of you probably have some experience with probate, whether personally or from family members, and a lot of folks have a difference of opinion on it, but that's what a will does. It writes in stone what the settlor, or what we call with a will, the testator had in mind for how their estate should be administered. Kind of orbiting around that will are the documents that are designed to speak during your lifetime. They're called disability planning documents or incapacity planning documents. That's the durable power of attorney and an advanced medical directive. So a lot of folks who have what we call just a very basic will plan, and we get that a lot. We get a lot of people call and say, we just need our wills. Well, again, clients are going to get whatever they want, but typically it would be inadequate and incomplete for someone to have an estate plan that only constituted that testamentary document. Because what about you now? What about you when you get older? What about you in the event maybe you get sick or you get hurt or you lose your capacity, which frankly just about all of us do, and everyone's living longer these days, and so the odds of that are just kind of shooting up. By having these documents in place, you obviate the need for anyone to ever have to go into court and petition to qualify as your supervised guardian and or conservator. The advanced medical directive, which is the document that governs the handling of your personal well-being while you are alive but incapable of making decisions for yourself, that obviates the need for a guardianship of an incapacitated adult. And a good, durable financial power of attorney gives agency to someone to serve as your attorney, in fact, to make decisions and maneuvers and transactions on your behalf with respect to your assets while you're alive. That obviates the need for a conservatorship. And again, I'm not here to cast judgment on these government processes, but a lot of folks want to avoid them, particularly if you are cost sensitive, which we all should be, if you are private, at least in some regard, or if you just want speed and to know what's going to happen. A guardianship and conservatorship, we've done many of these. I don't go to court on them anymore. I did them quite a bit years ago, is essentially this procedure. And like all court procedures, it takes time. It takes time and it takes quite a bit of money to pay an attorney almost always to petition a court, to provide notice to all the statutorily interested people, and then to get in there and help a judge understand why this needs to happen, why it needs to happen in this way, why you or your brother or your spouse or your oldest child or whomever is a suitable person to serve this important fiduciary role. And then, of course, aside from the delay and the expense and the kind of public nature of all this, there is an accounting procedure. So every year that conservatorship and guardianship is up and running, so to speak, it is accountable, and for good reason, to the local commissioner of accounts. And this, as you can imagine, is just it's a lot of process. It's filing fees. Sometimes the accountings are rejected, or the commissioner needs more information, or if you're late, there's problems. It can end up being a fairly cumbersome process, and you skip it completely. You just have a good power of attorney and advanced medical directive. Power of attorney is, and I've seen one-pagers, and those were kind of in vogue in the 80s and 90s, usually is what I see these days. Obviously, the state of the law has evolved quite a bit. Those powers are more robust now, but we also are very careful which powers we put in them. A general power of attorney suggests, well, everything. Generally, you have the power to handle my 401k, my life insurance. Go ahead and change the beneficiary. My stock account, buy, sell, my house, get a HELOC, what, all of the things. You can think of it that way. The Virginia Code wants us to expressly grant when we want to grant certain powers. And so, suffice it to say, the process for getting an appropriate power of attorney involves a conversation with what assets you've got and who you're comfortable controlling them for you, what powers you're not comfortable granting. And then what, if any, scenarios require further customization so that you feel comfortable that no one is going to abuse these powers and that they're not going to maneuver in a way that would make you uncomfortable. Now, people who act under these documents are fiduciaries. So a principal, that's you, the maker of a power of attorney or advanced medical directive, they give this authority to an agent. That agent becomes a fiduciary who has a very clear duty to act only in the best interests of you, the principal. But naturally, sometimes if we don't have a nice deep bench of people that we really, really trust, it can be concerning as to, well, who's going to wield these powers? And am I leery of giving too much power to any one person? Those are the conversations that happen. The big decision that also needs to happen with a power of attorney, because there's really two flavors of that, are, do we want this document to be effective immediately, the day you sign it in a conference room in front of a notary, right? Does the agent under that document have the ability to now take that and go straight to Bank of America or Truist or Park and Herbert or hire a realtor or do any of the things that are authorized in that document? Are you comfortable with that? Most people are, honestly, and they like that for the convenience and the flexibility that it offers. As I said, the first 300 powers of attorney I ever wrote were for young soldiers about to deploy into the Middle Eastern theater. And so they had to leave the flagpole back home for someone to sign the lease, right? Sign the paperwork, hire the movers, sell the car, re-register the car, sell the house, all of those things. And so oftentimes an immediate power of attorney was absolutely necessary because the alternative is what we call a springing power of attorney. That means that document only begins to speak or have impact when a physician has certified in writing that the principal is incapacitated, typically due to some sort of medical issue or event or trauma. And so you could see a scenario where that's not good enough for a well and healthy and able-bodied 25-year-old soldier who's just going to be gone for 9 to 15 months. That document needs to be immediate. And that is the truth for anyone who travels a lot and needs their spouse or their daughter or their best friend to be able to make these decisions here and now. But it's an important distinction that you need to talk about. Let's see. The Advanced Medical Directive also is extremely customizable, and the Virginia Code, through the development of case law and the Terry Schiavo cases and things like that of American history, have shaped those statutes, generally gives you the ability to give plenary authorization to the agent. Now, again, this document is only ever going to be used when you can't look the doctor in the eye and tell them what you want. And if the doctor, you can't look them in the eye and tell them things, but you are incapable of doing so in a healthy way because you've lost your mental capacity, well, then that document is all they've got. There are statutory fallbacks for who gets to have these roles by default. Oftentimes, people don't like how that priority list goes. You know, not everyone has a really good and close relationship with all the people in that statutory breakdown. Sometimes you include a spouse or parents or children. And so that's the opportunity to say, I want these people in this order making decisions about my physical body when I can. And then, of course, the content, the substance of that advanced medical directive is extremely personal. And some people myself included. I'll throw it out there. I give carte blanche, full authority to my agent to make absolutely any decision under the sun, except for one. And this is something you may have heard of called a living will. I'm sorry it's called a living will. It's very confusing that it's called a living will. It's not a will, as you understand it. It's a directive that I say to the hospital, to the assisted living facility, to whomever's using this document. I give my agent full authority to make every decision under the sun except for one. If you, the physician, have certified that I am in a persistent vegetative state and I have no prospect of recovery, and I'm not going to get out of that bed, I'm not going to walk out of there and tell you what I want ever again. I have no brain activity, right? Or I am only alive through that ventilator. I am telling you right now that I want that withdrawn and I wish to be permitted to die naturally with only pain medication and maybe some hydration. That's it. Let me die a comfortable, natural death. But there are those who want to really scope what they want the document to look like. How many physicians should be involved? In this situation, I want that. In that situation, I want this. And so it's a very important document, as you might imagine, not only because you've eliminated the risk that your loved ones are going to have to go to court and get a guardianship over you, but because you have the ability to kind of shape what's going to happen in a very concise and enforceable way. So there you have it. That is a last will and testament based plan. Last will and testament, power of attorney, and an advance medical directive. There is kind of that third species, and it's essentially the gold standard of modern estate planning, and it's a revocable living trust-based plan. I'm going to hopefully have a minute here to talk about beneficiary designations again, because it's extremely relevant, all three of these plans. But in a revocable living trust, you have decided, yes, I want to determine what's going to happen exactly after my death in the same way as I would in a will, but you've actually done it in a kind of hybrid arrangement by which you create your alter ego. That's what your revocable trust is. It's you. It uses your social security number, and it is completely tax neutral. And it is neutral with respect to creditors. People think, oh, it's in trust, no one can get it. Or if I get a car crash, they can't take my house, it's in my trust. Not true. A revocable trust is essentially cardboard box in the middle of the kitchen table. And it's completely customized. It's perfect. It's beautiful. You said exactly what it does and who's the trustee and how that share is going to be handled and how we're going to control this over time. And what happens in this situation? And then what if these people predecease me and I'm leaving everything to grandchildren, but they're too young? How should I handle that? Or how should I handle these assets for a special needs beneficiary who might need to preserve eligibility for public benefits, like Medicaid, for example? You can get extremely sophisticated with these instruments, and they are in that box, right? But until you start putting your assets in the box in real time during your lifetime, it's essentially empty. And so the two common misconceptions about revocable trust I want to address are: one, once it's done, it's done. I've done it. I have full peace of mind. I have a trust-based plan, the state of the art, right? There's a little more work involved because yes, it acts as a will substitute after your death. And now it's dictating what happens and who's going to handle it. But it only speaks to documents, and I'm sorry, it only speaks to assets you've put in the trust. Let's talk about what that looks like. You need to fund it. You need to not only go through the effort of designing it in a way that gives you peace of mind and addresses all the situations and sees around corners and reasonably foreseeable circumstances for you. Then you need to start putting your assets in it. It's called funding the trust. And every asset you've got essentially has a different journey into the trust. So real estate, deed. In this office, when someone wants revocable trust and they're a normal vanilla person like me with one piece of real estate, some kids, some other assets, you write the trust. And then same day you sign it, you sign a new deed gifting your real estate to it. So now if you go to land records, you'll see my house in Mount Vernon. It doesn't say Chris Leighton. It says the Leighton Family Trust. It owns it now so that it can dispose of it whenever. What's interesting about that is not everything goes in right now. That cardboard box in the middle of the kitchen table. Certain things can, you put your tangible property in now. Tangible property is absolutely something we put in at the table. If you own interest in a business, that can go in now. You can now we're going to go beneficiary designations, retitle assets to its name, right? A brokerage account, a bank account, certain things like that can just be retitled into it. But then certain assets never belong in it while you're alive, but you still go through the mechanism of making sure every asset is connected to it. And by that, I mean 401ks, life insurance, TSPs, IRAs. They should name the trust as a designated beneficiary or a payable on death beneficiary or something like that, so that at death, that's the trigger. It pays straight into it by operation of contract law. What I'm talking about here is essentially a revocable trust is designed first and foremost to avoid probate itself completely. And that's what most people love about them. They come to me and they say, well, whether they're a taxable estate or extremely wealthy or they're normal folks, or they haven't got all that much in terms of assets altogether. Some folks say, look, my number one priority is I had to be the executor for my mom and dad, my brother, my neighbor, and it was awful. I don't wish that on my people. What do I do? Well, you avoid probate with a revocable trust-based plan. And that document essentially serves as the will substitute at your death, but completely privately, free of probate tax, free of the probate process, and free of the public record as well. So a lot of folks who value their privacy and have very intimate, sensitive things in that trust, whether it's because of a sensitive situation with a family member or a disinherited family member or unique assets or extreme wealth or controversial assets, right? Things like that, or controversial or, disputed business interests, whatever it could be. That document is never read by the probate court. It's never recorded anywhere. In fact, unless there's so much wealth involved that a federal estate tax return is to be filed, it is designed so that the only people who ever need to see it are the trustees and the beneficiaries. And if there's no dispute, it never goes to court. So the revocable trust does first and foremost avoids probate. Two, it of course has a more nuanced way of controlling and disposing of the property that you want to hand down to folks, holding it in trust rather than just an outright distribution, for example. And then what I would say is really relevant to all of us these days is it's also an elder planning device, because it is not just a testamentary instrument the way a will is. It is also kind of like a power of attorney in and of itself, because when you put those assets in it now in real time, the trustee has access and control over them in real time. And how a revocable trust is typically drafted, I'll just use mine as an example. I am the settlor. I settled it. I created it. I alone have the power to revoke and amend it and tweak it over time and use the property I put in it any way I wish. There's no accounting to anyone for it. I can still enjoy the same relationship to the property as I did beforehand. But if I lose my capacity, or frankly, if I just don't want to do it anymore and I want to resign as trustee, my successor trustee steps in immediately and is right behind the wheel instantly. No court permission, no 4-week delay, no probate tax, no anything. That person is just now my personal fiduciary. Think of it as your Guy Friday. And that person is able now, as your fiduciary, you remain the beneficiary until the day you die, to leverage and use the assets in the trust exclusively for your benefit. So in this instance, my benefit situation is, because I've put my brokerage account in it, because I've put my tangible property in it, because I put a money market account in it, and because I put my real estate in it, if I'm 97 years old and I lose my capacity, my successor trustee can step in instantly, sell my house, get the liquidity, and put me in assisted living where I need to be, or get me the in-home care I need. Can wield my own assets rather than having to use their own. So I'm not burdening them personally, any of my three children, most likely, to have to come up with liquidity to take care of dad. We're going to take care of dad with his own stuff, and we're going to do it now, and we're going to do it privately. So I would say the elder planning piece is often lost in the conversation of what a revocable trust is built to do, but that I think is one of its finest features. So I'm going to pause for a second and address some questions because some good ones are popping up. Recently, we were informed that setting up a TOD, transfer on death option for investment serves the same purpose as a revocable trust for avoiding probate. Would advise this option. I would advise it depending on the circumstances. If we had a conversation about it, I would hopefully give you several options and you pick the best for you. But like I said, yes, having a designated beneficiary or transfer on death, TOD, or POD, payable on death, these are things that a bank account can be tagged as, can be designated with. It has the effect of transferring instantly, free of probate, that asset to its designated beneficiary. That is something people do in the no plan all day long, and it works. It works so long as that person outlives you and has capacity themselves, right? What it doesn't do, and so oftentimes I advise this route, and I don't want anyone to think when folks come into an estate planning or trust and estate office that they are being slowly sold into a revocable trust. Revocable trust does not fit everybody. It's not necessary. Not everyone needs that sophistication. Some asset groups and some families are such that just go with a standard will, but then we're still going to avoid probate by the way we designate these assets. And there's multiple ways to do that. Have a payable on death beneficiary or a designated beneficiary, or have a joint owner, right? Some folks add their oldest kid on the account. Now, the difference there is they actually are owners now. And unfortunately, it's happened. They can just use the assets any way they wish, and they're breaking no laws, okay? Sometimes when net worths come into play, we want to make sure we're doing tax optimized planning with when we transfer wealth to people. Going back to the revocable trust, again, this is uniquely suggested that if you want to do this type of planning, you would do it in a revocable trust rather than in a way that it's supervised by the Commissioner of Accounts in perpetuity every year that a trust under a will, for example, would be administered. But some folks don't want to just give the full investment account to this person, whether it's because they're concerned about their marriage. Of course, the divorcing spouse is the number one creditor in America, right? So I'm worried about my grandson's marriage. And if I give him the whole brokerage account, it's his, which means if he's not extremely careful, could end up on the chopping block in a divorce proceeding, right? And so the trust is a solution to that. Trust planning leverages strongly asset protection. So by that, I mean, instead, you have that investment account transferable on death to the trust, and it fills a share for the grandchild, but it's held in trust, which means it's not the grandchild's. It's in a trust for their benefit, and there is a big difference because the grandchild doesn't have the right to demand it. That in fact, a trustee uses discretion when determining when to make distributions from it, makes it not his. And because it's not his, it's not accessible to his creditors. Another prominent feature of that is, of course, let's say it's a big old investment account. Talk about taxes for a moment. We're all Virginians, I understand, on this call. So we don't currently have to worry about something called a state level estate tax. Marylanders do, Washingtonians do, folks in Massachusetts do. They call it Taxachusetts for a reason, right? Extremely low exemption levels. Virginia has none. So we only, as Virginians, in terms of estate taxes, concern ourselves with the federal limit. And under the One Big Beautiful Bill Act, it is now $15 million per taxpayer, which you can stack with your spouse, a U.S. citizen spouse, for $30 million. Can be sheltered free of any transfer tax. The amount above that takes a very big haircut, 40% straight to the IRS. So folks in that situation, we call that a taxable estate, obviously have a completely different problem set that we plan around. That's the tax planning that we talked about in the beginning. It's for another day. But whatever the values we're dealing with are, let's just say it's a $3 million account and you want to give it to your grandson. Well, you can sure just make it TOD to the grandson. What if he's independently wealthy, or you expect that he will be? Well, if you leave it for him in trust, it's not includable in his $15 million lifetime limit because, again, it's not his. And if he predeceases you or passes away with assets remaining in that share, you control what happens next. The most common one is, well, to his kids, right? And then it drops to that next generation in the same creditor protected and estate excluded posture. So we're kind of getting into the weeds of some of the more sophisticated nuance of the revocable trust, but that's just to give you a sense of all the different considerations when we do it. Now, a lot of folks don't want or need these sophisticated considerations when you do a revocable trust. You just want something there to avoid probate and be ready to take care of you when you can't anymore. That's a really common starting point for normal folks like me who don't have a taxable estate, don't expect to have one. But another good question's been asked. Does a pour over will cover assets that you haven't put in your trust? Excellent question. So now I want to step back again and complete the picture of what a revocable trust-based plan looks like. Remember, the note plan is not a single document. A will-based plan is the last will and testament, power of attorney, and advanced medical directive. A revocable trust-based plan is all of those. So you still have your revocable trust, but you have an advanced medical directive because the trust doesn't control procedures and medical decision-making and assisted living admissions and things like that, and organ donation and living wills and all types of clauses to consider what you want or don't want based on what could happen to you physically. Still have a power of attorney. Why would I have a power of attorney? I thought I moved all my assets into the trust to be controlled by my trustee. Why would I need an agent under a power of attorney? It's because some assets do not belong in the trust while you live. Those are typically retirement accounts, right? The employee is the owner of the retirement account. Section 401k of the Internal Revenue Code makes that clear. And so that 401k may designate a beneficiary that's a revocable trust, but it's going to be you while you live. And so if you lose your capacity or mobility, or you just can't get around to handling your RMDs or making your distributions or any of those things, you got to have someone to do it for you, and that's that agent on the power of attorney. Okay? Pour over will. You get a will with the trust. You're like scratching your head saying, I definitely don't want that thing now. But a pour over will is a very simple, basic will that accompanies a revocable trust. And its whole job is to kind of float underneath the trust as like a safety net in case you forget to register all your assets to the trust. You either forget to put them in the trust or designate the trust as a beneficiary, and it's stuck in your probate estate. Most common example we saw was that life insurance policy that she had before she even met her husband. It only designates her mom and dad. She got it in the 70s, right? But it's worth a couple $100,000. It is now payable only to her estate because the designated beneficiaries did not outlive her. Same risk you run with a simple TOD designation. That's why when you designate the trust never dies. So you never run into that problem. But if you do, for some reason, have an asset with no living designated beneficiary, that means it is in your sole name. That means it's going to probate. The pour over will is floating under the trust to address that exact situation, because its only job is to go grab that asset you forgot, get it through the probate process, and pour it over into the trust. So that still at the end of the day, everything shakes out, is handled, managed, controlled by the trustee exactly as you wanted it, as you stated it in the trust. So very good question. Let me see if I can address one more. What happens to one's assets if one dies without an estate in place? Someone's got the no plan. It's called probate. It's called intestate probate. If you haven't got a will, different procedures attach in probate because you died intestate. And then Lady Virginia and the Virginia Code and its many statutes will determine who has priority to become your executor if they wish to include creditors. Creditors can become executors of, we call them administrators of an intestate estate. And then, well, who's going to be your takers? Who's going to get the property? They're called your heirs at law. And if you want to, I think Victoria asked that question. Victoria, if you want to look at Google Virginia Code 64.2-200, that's going to be a breakdown of who your heirs at law are, who's going to receive your property. If you've got a spouse, spouse. If you don't, but you've got kids, the kids. Kids pass away, but you've got grandkids, the grandkids. If not, then it goes up, find your parents. No living parents, siblings. No siblings, nieces and nephews. And then that branch of the family tree as a class becomes your full takers of everything outright. Just outright. Just write them a check for the balance of the net probate estate. So folks often don't want the Virginia Code to control their estate plan. And so that's why often you audible out of that no plan into either a will that makes clear who gets what, when, and how, or a trust. Great question. The no plan, though, considers that possibility and is aware of what an intestate estate looks like, and hopefully at least does a really good job designating viable living designated beneficiaries, because then we avoid probate with those assets at least. So another question. The successor trustee of my revocable trust lives in New York. How can we plan to have someone local to help her? Well, again, a U.S. citizen can administer a trust from anywhere. And it's not a problem that they're in New York, but I think I understand what you're saying. It's really going to be informed largely by how well you funded your trust during your lifetime and how suitable and savvy this individual in New York is. Trusts that we write are always very clear that the trustee is not alone and is authorized to get assistance from CPAs, investment people, attorneys at trust expense. So you don't have to worry that, oh, I don't have anyone in my life with a law degree and a Series 6 background and also an accounting license. I don't have that, so I don't have a trustee. If you just have someone with a good head on their shoulders, they're allowed to call Lifeline to get help as needed. So hopefully that addresses your question. But the other myth I wanted to dispel about the trust is that it's just for rich people. I'm not a rich person. Obviously, I gave myself a great deal on the trust I wrote for myself, but it's not just for the wealthy. The wealthy, right? Folks who have what we call taxable estates or wealth above what the federal government will exempt free of tax, they absolutely need to at least be doing this planning. But typically, if tax optimization is a goal of theirs, they do the tax planning we talked about in the beginning. And so if you ever grew up knowing someone who had a trust fund, oh, he's got a trust fund, or you had a trust, and it was in existence, and you were benefiting from it, and it was created by someone who was still alive, that's an irrevocable trust, and that's a completely different kettle of fish. Revocable trusts are estate plans for people who prioritize things like probate avoidance, elder care, and then maybe a little more deliberate ways of distributing the property, either because they're concerned about creditors or taxes or things like that. So not to overwhelm you, and we're coming up on time, but it's just a brave new world of topics that we address in a revocable trust. But there are all good options in front of you. And I think the important thing is that you just take the opportunity to find the one that fits you now. This is done so affordably and so pain-free with just a little bit of planning. And when clients come in with a little bit of understanding of what they want, we sit down, we talk for at least 30 minutes about you and your goals and your life and the people in it. And then the approach is to propose things that fit you. When you do that, you have spared yourself and your loved ones not only probate most often, but any kind of uncertainty, any kind of bad scenario, and any kind of judicial involvement at all. And that's frankly usually the peace of mind gift that we like to give our clients. So that's really the last bit of substance I was going to add, but I will ask a few more questions. And the last one I see here is, how often should you review and update your trust or your will? I get that one a lot. Sure, there's a rule of thumb. Every 3 to 5 years. But every year you should be looking at this thing and asking yourself if it still fits. Because while it's a bit of mental energy to get this particular trust set up right and funded now, it's one and done. You never have to do it again. And making small little course corrections and changes over time. I have clients who are on their 11th, 12th, 13th amendment to their trust. They're very inexpensive. It's very quick and it's very painless. You don't have to go back and retitle these assets all over again. You've already done it. You're just kind of stapling a new provision to the back of the document, so to speak. And so I say every 3 to 5 years, you ought to really consider whether I need to update this. If you happen to have an attorney, they should be notifying you if there's a big change in the tax code that should precipitate an amendment or a review. But other things that are personal to you are the other two drivers of amending documents, and that's big changes in your personal life, big changes in your wealth. So I would say those are the main occasions for you to review your documents. So that's all I've got in terms of content, but I'm happy to address any other questions you may have, or if you want to shoot me an email later, I could follow up at a separate time.
We had an earlier question about what's your advice for how to manage or safeguard original estate documents so that they're available to the executor upon death?
Great question. Great question. Sorry, I missed that. So everyone's favorite lawyer answer kind of depends. Depends on the plan. If we are talking about a will-based plan, this is one thing I didn't mention, but one of the many protocols you need to be aware of with a will is the probate court needs the original will. That one, the one you signed with the wet ink and the notary stamp. That is what is required to initiate probate. If that is lost, you can petition the circuit court. Now you're talking about an attorney and a court appearance and notice and all that to probate a copy of the will, overcoming an evidentiary presumption that the testator destroyed it because he didn't like it anymore. So if it's a will-based plan, fire safe and make sure people know how to get to it. That's where mine is, for example. But if it's a revocable trust-based plan, you have a funded trust, well, it doesn't really matter. Your attorney, first of all, ought to have it secured in their cloud-based servers. But we execute documents. We send our clients all the originals, and we send them PDFs or flash drives with everything. And we encourage you to actually distribute them to those people now. So if you just come in and you do a basic plan, I say, well, here are your original documents. I encourage you to send copies of each and every one of them to your executor, to your agent, to your trustee, because I see what the call to question is here. There's nothing worse than a plan that you can't find. Well, I know Dad had a trust, but I've got no idea where it is and no one can get their finger on it. So the document's only as good and enforceable as if it's found. The folks in your documents should know where they are and how to get to them. A lot of folks like to go with safe deposit boxes. The annals of trust and estates are replete with examples of horror stories of getting into those safe deposit boxes after death. Court orders and drills are often involved. So just be thoughtful. I personally have a $40 fire safe from Costco, and it's got a keypad that everyone who needs to know knows the combination of.
So if somebody is searching for somebody to help with estate planning, how do you vet the lawyers and the firms to make sure you're not picking somebody that's got, complaints or disciplinary actions or, not enough experience or anything like that?
How do you vet us? I will say the majority of my clients are referred to me from prior clients, from other people who I've worked with, or from wealth institutions that I've worked with. But certainly you have the opportunity, better than most these days with the internet, to, I would say, go to that attorney's website. Make sure they have a website. Study their background, right? You can learn a lot just by looking at a lawyer's bio. You can learn a lot if that person purports to do every kind of law there is. That's probably a signal that they're not really a trust and estate lawyer. And that is actually something we deal with quite often. Folks will come to us with broken documents or they'll come to us after the fact with their parents' documents and say, we've been working with this attorney, but it is just crystal clear that they don't actually know what this stuff is. And so I would say the internet, you can put whatever you want on your website, but there are agencies like the Virginia State Bar, right? And you can track disciplinary actions that way. People tend to have ratings and reviews. I think reviews are really important because that's the good and the bad of the internet as an attorney, right? Anyone's free to say whatever they think about the plan I wrote for them. So just like you're buying a new grill from Costco and you want to click on the reviews and some people give you 1 stars and tell you why, I think that's important and you should read all of that. But word of mouth referrals tend to be important at the risk of sounding self-serving. So people who are not only known among lawyers in the bar for doing this, who are members of certain sections of the bar, who serve on boards of directors of, like I serve on the board of directors of the Alexandria Bar Association. So we vet each other very closely. But then read the full bio. You'll see if you go to mine that I teach a seminar of estate planning and Catholic law. There are some folks who got a mile and a half of extracurriculars, and that should really be a good indicator that this person's not only been doing it for a long time, they've been doing it at a high level, they're published, they speak routinely at events like this. That's a good bellwether of a good attorney.
Okay. Well, we've got about 2 minutes, so if anybody's got one last question they want to ask, now's the time. Well, I guess not. So, Chris, I want to thank you. There was a lot of information here today,
Was.
and but you presented it, I thought, very clearly and answered a lot of questions. So,
I'm happy to hear it. It was a pleasure to be invited and to get to speak with you folks a little bit. Sounds like you're part of a great organization that's going to keep you abreast of important things like this. So anything I can ever do to help you all, just let me know. But hopefully I'll see you around at one of these famous A&V happy hours.
okay. Carolyn, do you have anything about next week's?
I should be ready for you to put me on the spot like this. I really should. No, I do not. I think that somebody may have put it in the notes, but if not, check out um, the biweekly email blast, which will come out on the 1st.
All right. Well,